Hello and welcome to the View from Mayor Brown podcast. This is a fortnightly podcast series for employment lawyers and HR practitioners which highlights developments in case law and legislative changes of importance to UK employers. It is presented by Nicholas Robertson, the head of Mayor Brown's London employment team. The time spent listening to these podcasts can count towards your CPD requirements, and at the end of the podcast we will explain how to get in touch if you wish to claim CPD points or if you have any comments or questions.
Hello and welcome to podcast number 106. This is the last regular podcast which I'm going to do this year. Next week we'll have a review of the key cases which occurred during 2016 and, if time permits, a quick look at some of the pleasures that await us in 2017. Of course, we have a particularly key case going on at the moment, namely the Article 50 hearing in the Supreme Court. And for those of you who've not yet caught up with it on Twitter, can I really strongly recommend the quite fabulous Rupert Myers, M-Y-E-R-S, Twitter feed, purportedly coming from the Supreme Court with the real goings-on. Of course, it's nothing of the sort, but it is undoubtedly post-truth, but it's very funny. Anyway, back down to earth. Our last three cases for 2016 cover a restrictive covenant case involving hairdressers, who else, working time regulations and breastfeeding. I like to think we get around in this podcast, cover life's bigger subjects. As usual, don't forget you can access the podcast via iTunes, it's on the Mayor Brown internet, YouTube and the Twitter feed Nicholas Robertson at NicholasRobber11, which is also where we post out links to the cases we've discussed. Well, first case, Rush Hair Limited and Hayley Gibson Forbes and others. And this case concerns the enforceability of post-termination restrictions in a business sale document. Obviously, as employment lawyers, many of the restricted covenants that we see will be contained in contracts of employment. But we've also had to advise on the enforceability of post-termination restrictions contained in business sale documents on a number of occasions. And there are now a number of cases kicking around where the courts have had to consider these types of covenants. So in a case such as this one, where the court had to grapple with a number of issues, it's a useful roadmap. How are they going to go about addressing issues? Rush Hair Limited operated a franchise back in 2008, and I've looked long and hard, but I couldn't find any link to the legendary or not so legendary Canadian rock band, so we'll just have to assume it's a coincidence. Anyway, Ms Gibson Forbes entered into a franchise agreement with them in 2008 in respect of a hairdressing salon in Windsor. Franchise agreement had post-termination restrictions, provided she could not carry on business within 1 mile of the relevant premises, which were competitive with a Rush business. There was a definition of Rush business. She apparently, in the years that followed, built up a very successful operation and ended up having a number of hairdressing salons, which were sold to Rush in 2015. As part of the consideration, she agreed that she would not, at any time during the period of 2 years from completion, quote, canvass, solicit, entice or employ, unquote, 3 named individuals, and for 2 years from completion she wouldn't engage in any business which competed with the Rush business. However, there was no definition of Rush business in the sale documentation. The covenants applied for a 2-mile radius around the Windsor site and another site at Maidenhead. At the same time as the sale, she also terminated her employment and reaffirmed the SPA covenants in the termination agreement. It was alleged that she had set up then a competing hair salon in breach of the post-termination restrictions and had also employed one of the 3 named individuals in the salon, or alternatively that she had canvassed or solicited that individual to join her. There are a number of issues which the High Court had to deal with at the end of a speedy trial. It's important to note that this was not an interim injunction. Indeed, the interim injunction was rejected for reasons we're not told in the final judgment. However, it does mean that the court has heard evidence and has reached a fully reasoned judgment based on facts that it has determined. And this, I think, adds to the weight of some of the observations it makes. High Court started off by reminding itself that the test for the reasonableness of restrictive covenants was usefully explained in the TFS Derivatives Limited and Morgan case, which is a case that we did about 10 years ago. The court starts by looking at what the covenant means when properly construed. Then it asks, has the employer shown that it has a legitimate business interest requiring protection? And then, in relation to that interest, is the covenant no wider than is reasonably necessary for the protection of those interests? Looking at what amounts to reasonable necessity, this can be assessed, according to the TFS case, from the perspective of reasonable persons in the position of the parties as at the date the contract was entered into, having regard to the contractual provisions as a whole, and to the factual matrix to which the contract would then realistically have been expected to apply. That last part's important for reasons which I'll explain. The first issue, which the court considered, and which I want to turn to, is the interpretation of the covenants affecting the canvassing or soliciting or employing of individuals. Ms. Gibson-Forbes took the point that the competitive business which she was running was run through a limited company. She herself had not contracted with the named individual. She was not the employer. The court considered whether this was one of those cases where it was appropriate to pierce the corporate veil, because there was no doubt that Ms. Gibson-Forbes was the owner of the business in question. The court looked at the cases dealing with the circumstances in which it was appropriate to pierce the corporate veil, and said it was not appropriate to do so here. In general terms, piercing the corporate veil only occurs when the company is being used to hide the identity of the real actors concerned, or where the company has been put in place to defeat or frustrate a right to enforce directly against the individual. Neither was applicable here. She had not hidden for a second that she was behind the company. However, the judge decided that the clause itself, the post-termination restriction, was sufficiently ambiguous to allow him to take into account the background knowledge which the parties would reasonably have had at the time the contract was entered into. It was well known to both parties that Miss Gibson-Forbes had previously operated hairdressing salons and had always done so through limited companies. Therefore, both parties would have understood that the covenant would extend to apply to Miss Gibson-Dunn, so that she would be prohibited from canvassing for herself or as an agent for another, i.e. a company. Therefore, the covenant in principle applied, even though she wasn't directly employing the individual concerned. The court then had to look at how to handle the fact that there was no definition of rush business in the SPA. Definition could easily have been included because the franchise agreement, which had been entered into at the start of the relationship, contained a definition of rush business. The court, however, felt there was no difficulty in understanding what the term meant. The reference to rush was understood to be a reference to Rush's hairdressing business. This was clear from the sale and purchase agreement and did not involve reading across the definition from the original franchise agreement. In looking at the reasonableness of the covenants, the court accepted there was not proper equality of bargaining power, even though this was a business sale. The court acknowledged that the consideration paid was substantial rather than merely nominal, which was important. The purchaser, Rush, was entitled to protect the goodwill that it was buying. There was an attempt to argue that restricting the individual for 2 years following the business sale was for far too long a period to justify enforcement. This would obviously have gone to the heart of the covenants, because it wouldn't have been possible for the court to impose a lesser period. If you had an employment covenant that applied for 2 years following the termination of employment, I think that would be pretty difficult to uphold in all but the most senior or extreme cases. However, here, in the context of a business sale, the court was quite happy to uphold the covenants. Previous recorded cases had upheld covenants with a restriction period of 2 years. And the judge in the Rush case pointed out that the earlier Cavendish Square case, in which the judge in that earlier case had said there had been no vendor-purchaser case, under English law, reported at least, in which an otherwise reasonable post-termination covenant had been held to be unreasonable solely on the grounds that the covenants were too long. So, in those circumstances, the judge was relatively comfortable about finding that the 2-year period for the restriction was enforceable. Emphasise, of course, we're talking about an SPA document covenant, not an employment covenant. So, overall, I think this is a helpful definition of the way the court will approach matters. Drafting niggles might be a distraction rather than a full-stop Mexican wall, to use a Trump term, preventing the enforcement of the covenants. Here, although there were drafting niggles, the failure to define rush business, the slightly inadequate drafting around whether or not employment by a company was enough to catch the new business owner, that didn't deter the court from finding there were reasonable restrictive covenants and were capable of being enforced here. It's undoubtedly key that it was a business sale document rather than a contract of employment document, and there's no suggestion that the defendant has set up a company purely to try and frustrate the operation of the restricted covenants. However, the establishment of that company didn't prevent the covenants being applied, although clearly it would have been better in retrospect if some of the drafting had been just a little bit tighter. So, that's the case of Rush, Hair Limited, and Hayley Gibson-Forbes and others. So, 2 other cases to go through, and they're both slightly shorter than the one we've just been through. Grange and Abellio London Limited. This is a case on the working time regulations, and it's a small but a significant point. Let me explain. The claimant worked as a bus driver for the respondent. Initially, his work was rostered with scheduled break times in order to comply with obligations under the Working Time Regulations 1998, and in particular, Regulation 12. And this regulation specifies that where a worker's daily working time is more than 6 hours, the worker is entitled to a rest break, of an uninterrupted period of not less than 20 minutes, which the worker is entitled to spend away from any workstation. The working time regulations are, of course, based on the Working Time Directive, which states that, quote, all workers shall have adequate rest periods, unquote, and that, quote, member states are to take the measures necessary to ensure that where the working day is longer than 6 hours, every worker is entitled to a rest break, unquote. As the court pointed out, the language, it refers to this as an entitlement to a rest break rather than an obligatory or requiring an individual to take a rest break, irrespective of the worker's views. In the initial period of employment, the court commented on occasions when it might have been difficult for the claimant to fit in a break because of the work schedule that he was working to, but there was no evidence that there had actually been a refusal of his right to a rest break. In 2014, the claimant submitted a grievance, however, suggesting that there had been an adverse impact on his health caused by being forced to work continuously without an appropriate rest break. The key issue was whether the claimant had to show that he'd asked for a rest break on a particular occasion and it had been expressly refused by the respondent, or was a lesser standard of proof necessary. If the employee was claiming that there had been a breach of legislation, she needs to show under Regulation 30 that the employer has, quote, refused to permit him to exercise, unquote, his right to a period of uninterrupted rest. Refused to permit him to exercise. The EAT in this case was faced with conflicting prior EAT decisions, but came down firmly in favour of the employee. It said that the entitlement to a rest break was to be, quote, actively respected by employers, unquote. It was not enough for employers to permit workers to take rest breaks in accordance with the working time regulations. And although employees couldn't be forced to take rest breaks, according to the EAT, employers could be expected to actively ensure their working arrangements allowed workers to take those rest breaks. It was enough if there was a de facto refusal of the entitlement to a rest break, even if it hadn't been expressly demanded by the worker. So this enabled what the EAT referred to as the real-world protection of rights to rest breaks, unquote. So accordingly, an employer has an obligation to afford the worker an entitlement to a rest break, and if that is refused, if the worker puts in place working arrangements that fail to allow an individual to take 20 minutes rest break. If the employer takes active steps to ensure working arrangements enable the worker to have the relevant rest break, it will have met its obligations, irrespective of whether the worker then chooses to take the rest break or not. The EAT referred matters back to the Employment Tribunal to decide whether there had been effectively a refusal of the right to a rest break. And interestingly, on the facts, the EAT said this could have come up because individuals were too busy to take the break each day, or the individual had not been advised that he could take a meal break if he wanted one. Overall, I think the case is a very sensible one. It's clearly aimed at an employer who tacitly makes it impossible for an employee or worker to take a rest break without ever prohibiting rest breaks or refusing to allow an individual to take a rest break. Similarly, it removes the need for an employee or worker who may not know precisely what their entitlement is to demand the rest break and then have that request be rejected before they're able to bring enforcement proceedings. In practice, I can see these issues arising often for rostered workers, but also in the context of a dispute between employer and employee. For example, if an employee is claiming they're overworked, I can see the de facto rejection of a daily rest break argument being viewed as culpable behaviour by an employer. Might find the basis for constructive dismissal, for example. So, that's the case of Grange and Abellio London Limited. Last case, McFarlane and another, and EasyJet Airline Company Limited. This is a tribunal case on whether the employer, EasyJet, was guilty of indirect sex discrimination for not making appropriate adjustments to a work roster to allow leeway for two breastfeeding mothers who had recently returned from maternity leave. The individuals worked for EasyJet as crew members. It was accepted for the purpose of the tribunal hearing that they were covered by a provision, criterion and practice which required them to fly in accordance with their rostered flight patterns, which meant there was no restriction of the day on which the length of the day they could be required to work for, and indeed that included days which extended for more than 8 hours continuously. The claimant asked if they could be rostered so they didn't have to work more than 8 hours to allow them to breastfeed, but this was turned down by EasyJet. They did it on the basis, they said, of a legitimate aim to comply with their flying schedules, and that avoiding bespoke rostering arrangements was a proportionate response to difficulties caused by preventing the women from breastfeeding. Eventually some adjustments were put in place by EasyJet, but the claimants brought tribunal claims, and the claims were upheld by the Employment Tribunal. Looking through the tribunal decision, it does appear that the justification put forward for not providing bespoke rostering by EasyJet was long on generalised concerns, but very light on actual hard evidence of the potential of the problems that would be caused. However, on the other hand, there was clear medical evidence that preventing breastfeeding had potential health issues for the women concerned. So on the one side you've got assertions, maybe right, maybe wrong. On the other hand, you've got actual medical evidence. In the circumstances, the tribunal upheld the women's claims and awarded the financial loss, together with awards which averaged about £10,000 for injury to feeling. Obviously, this is a very unfortunate outcome for EasyJet. I think it's an issue which in one form or another comes into play often with maternity returners wanting different working arrangements from ordinary full-time, full-on work. Why is it impossible for the employer to try the arrangement and see how it works? Is what we often say to employers who've rung us up. Why not try it? Why not just try it, see how it works? If it doesn't work, you'll have the evidence it doesn't work. If it does work, then it works. Some cases there may be good reasons, but a tribunal would expect a level of proof as to why arrangements should not even be tried, particularly if the employee had, as they have here, clear evidence of a benefit that will accrue to them if the arrangements are adjusted. So, that's the third and final case of McFarlane and Another and EasyJet Airline Company Limited. I think it only remains for me to say thank you very much for listening, as always. No employees are harmed or mistreated in any way in the making of this podcast. Stay safe. Good luck with the Christmas shopping if you haven't done your Christmas shopping yet. And we'll speak one more time. We'll have one more podcast in a week's time, and it'll be a run through the year's events and some thoughts for 2017. Thanks very much.
So that was our latest podcast. We hope you found it useful. If you have any questions or comments or want to know how to claim CPD points, please email Nick at nrobertson@mayorbrown.com. Our podcasts are an overview of the cases, and how the law applies in any particular case will obviously depend on the individual circumstances. So please take legal advice if any of the matters discussed are relevant to issues you are dealing with. Thanks for listening.